Podcast Litigate. Collaborate, innovate, advocate for disability rights. Welcome to Litigate. In this podcast, we talk about the real challenges faced by persons with intellectual and psychosocial disabilities. Many people with intellectual and psychosocial disabilities face discrimination and barriers to justice across the EU. But legal action can drive real change. That's where strategic litigation comes in. It's not just about winning cases for individuals, but challenging unfair laws to create lasting impact. Through strategic litigation, advocates are working to hold the system accountable. In this podcast, we will explore these legal battles, meet the experts behind them, and uncover how the law can be a tool for justice. Brought to you by Litigate, funded by the Citizens, Equality, Rights and Values Programme of the European Commission.
Hello everybody and welcome to our podcast. Today's discussion is about challenges and triumphs of strategic litigation for persons with disabilities. My name is Simona Florescu from Validity Foundation. I am joined by two lawyers and disability rights advocates from Bulgaria, Aneta Genova and Vladimir Mirchev. Aneta has been working in this field for more than 20 years now. Aneta has a wealth of experience, having previously worked as a judge in Bulgaria. She also has an interest in social work and has a degree in art therapy. Vladimir is an attorney at law specialized in human rights cases, representing clients with disabilities in arguing for their rights, and together with Aneta and other Bulgarian lawyers, they have established the network of independent experts. The aim of this network is to pull together forces to develop strategies and to litigate for persons with disabilities. Aneta, Vladimir, welcome to this podcast.
Hi, Simona.
Thank you.
Aneta, I will start by asking you to reflect on how you have started working in this field.
It's a long story. Started many years ago, probably in 2003, when I studied clinical social work. I never finished this, but it gave me a lot of knowledge how to understand the psychosocial disabilities. In that time, there was visit organized by government in social care institutions, and they invited the students from university to participate to this team. And in that way, I took part. My professor invited me in such visit. It was in South Bulgaria, and I was so shocked to see how the people with psychosocial disabilities are living in social care homes. It was dirty room with more than 20 women laying on the beds. The smell was terrible. There were not windows. There was no light in the room. It was terrible, just out of my imagination. So once I went out of this, I decided that it should be done something. I couldn't live anymore knowing that it exists. So I start to look at programs where I can participate, and 2 years later I found that Mental Disability Advocacy Center, the previous name of Validity Foundation, looking for a lawyer in Bulgaria with the task to develop a program for protection of persons with psychosocial disabilities. So it is the way I started.
Vladimir, what is your experience with clients with disabilities?
Well, it was 5 years ago at the beginning of my career when I met Aneta and some other colleagues from the network. At the beginning, I was anxious and worried because this was totally new for me. And not longer after that, I realized that all you have to be is to be a human being. Things get much easier. That's part of the contact with the clients, and it's better to react to their problems, not from the position of a lawyer for the first time, to gain their attention and credibility.
Thank you, Vladimir. I was thinking for our audience, perhaps it would be interesting to hear some stories of your clients. Aneta, could you think of one client that have particularly impacted you as a person or you as a lawyer?
The obvious answer of this question is Rusi Stanev. It's Grand Chamber of European Court of Human Rights case. And we won this case. But actually, speaking about people who affected me, I have to mention many other people. Maybe Rusi was one of the first people I met in institution, but after him I met, I don't remember the number of people, but for sure we started more than 10 cases, even 20 maybe, trying to challenge the institutionalization of people with disability and guardianship, both of the concept. We wanted to prove that deprivation in social care home can be deprivation of liberty, and also that the guardianship prevent people to have access to justice. So I started at least 10 cases. Some of them didn't reach the final stage before the Bulgarian courts. Several finished. We exhausted all domestic remedies, and only 2 cases reached the level of European Court of Human Rights. It was one person from the social care home. He passed away during the procedure, and his case never been decided by the European Court. His sister wanted to prolong the case, but the court refused because she was the person who placed him in the social care home. So only Rusi survived, and he was able to go through the whole procedure before the European Court of Human Rights and after that.
What was the reason that brought you to deprivation of liberty and guardianship?
Actually, it's not one person work. It's a whole team behind this, even more than one team actually, because it was the Bulgarian Helsinki Committee working in this area. It was also Validity Foundation. A lot of people dedicated to research what is the consequences of the placement in social care home, involuntary treatment, all these things. So it was clear from human and legal point of view that deprivation of legal capacity leads to deprivation of liberty. So this exactly happened to Rusi, and he was placed under guardianship because of some conflict of his family, because he has crises and some problematic behavioral, and his guardian become somebody from a municipality, person who didn't know anything about him. So this lady for the municipality, the guardian, decided very fast to place him in social care home. It was in the mountain, more than 400 kilometers from his town, and in closed environments. He hadn't possibility to go out because his ID was kept by the director, and if he decided to go somewhere, the director had obligation to call the police. So it was real detention. No way to say something else when you know the situation. When it's exercised in this way, it's violation of rights.
When you met Rusi, do you remember how did you meet? How was the first encounter that you had with Rusi when you went to visit the social home?
It was in 2005 for sure. Maybe in the summer. He was placed in social care home in Pastra, which is a small village, very hidden in the forest. So I went there with a colleague of mine from Bulgarian Helsinki Committee. Actually, my colleague met him before, and they had a discussion that he wanted to start a case for remove the guardianship, and she helped him to send complaint to the prosecutor.
And was this a typical way that you would meet clients at that time, that you would visit institutions?
I participate in monitoring visits as a part of the team. I discussed with people their problems in different institutions. For example, I remember one person who was placed in a social care home by his ex-wife. After the divorce, she decided she doesn't need him at home anymore and placed him in the social care institution. I remember this person very well because he was very educated, very intelligent. He knew several languages, including French, English. Actually, I thought he can be very good advocate after all, but unfortunately, he also passed away and didn't survive to see the end of the legal battle. Actually, it's happened to many people. So yeah, it was very sad work actually, because we met a lot of people, we started something, and there was no guarantee that we will reach a positive end.
How long long would such a litigation take from the moment you met the client until you would get a court ruling in Bulgaria and then afterwards if you went to the European Court?
In Bulgaria, it was quite easy because in that time there wasn't a legal remedy to challenge the guardianship. Even Rusi and the other client with whom we reached the European Court of Human Rights, they hadn't right to start a case for abolishment of the guardianship. So it was easy. We just asked the court to start a procedure and the court refused. We asked the prosecutor to start the procedure because this was potential remedy and the prosecutor refused. And that's it. We hadn't anything. We couldn't start a case for compensation for inhuman and degrading conditions because person under guardianship cannot start such case.
Who could start these cases?
Only the guardian. But the guardian is the director of the institution who is create these conditions or who is dependent from the municipality or the government. Person who is under guardianship cannot start any other procedure. In the case of Rusi Stanev, but he couldn't start case for compensation for the inhuman and degrading conditions in the social care homes. It is possible to be started only by the guardian.
So what were Rusi's complaints in practice?
Years after this battle, he had a speech before a group of lawyers and people who had interest in this area. And I want to use his own words. His main complaint was that they are placed there to die. He was sure. He was witness of many people dying there. He wanted to work, but there was no way legally. So he had possibility to go somewhere close to the social care home and to work for somebody just for cigarette. He understood it's exploitation. He needed to be around people. He was a very social person actually. So he wanted to be married. It's prohibited by the law for people with psychosocial disabilities and who are under guardianship. He wanted to have a normal life actually.
And for all of these things, he needed the consent of the guardian who was the person in the institution in charge of supervising him.
Yes and no. To start case, yes, but to start work, it wasn't possible because he was under guardianship. It's prohibited totally. Even consent cannot help in this situation. The guardianship is something affecting his life totally. It's not normal life after that.
So you decided to start a case on his behalf, even though you knew that the case will be lost in
Absolutely,
Bulgaria.
yes.
Could you tell us why you took that decision?
Because we wanted to start case before the European Court of Human Rights. And the only way was to go through the procedure.
And when had you decided that this was a strategic issue, the issue of guardianship and deprivation of liberty?
We knew it's a strategic case since very beginning. It was clear because if we win the case, it means that we will prove that it's deprivation of liberty, the guardianship is harmful institute. And I have to say, Rusi was aware about this. He was sure that we are doing this not only for him, it's for everybody. He was absolutely dedicated to this case. It's really fascinating how they understand the role of the strategic litigation and meaning of their life to change many other people's lives.
So if I understand correctly, what motivated Rusi was not only to change his personal situation, but he wanted to change the situation of other people.
Yeah, he was aware.
He was aware of that.
He was sure that we will win the case. I was who had doubts. He was sure all the time.
And what happened to him, to his personal situation after the delivery of this judgment?
Actually, the change came before the decision. A little bit before that, he was moved from this big institution in his hometown in another kind of group home. In the beginning, he was in temporary home for people without homes. And then he was placed in a group home for people with psychosocial disabilities. And this place was in the center of the psychiatric hospital. And he told me once that he had more freedom in the big institution than now. He still was under guardianship. Once the decision came, he received his compensation. In that time, he hadn't a guardian. The municipality of Riva, which was the guardianship body in his case, decided that once he is moved, they couldn't be guardianship. There is no reason for the municipality to ensure a guardian for him. So they left him without guardian. So he received the money from the compensation, left without support, how to manage them. So being deprived from liberty and from social life for so long, he just spent them traveling and having fun. In one point, he rented a house. He left the group home. So he rented a house, but without support, he couldn't manage well everything. So he became homeless in one point. And then I managed to put him in touch with organization, which helped him a lot to improve his life and live in the society. But something happened. He again became homeless and ended up in another institution. It was named group home, but it was kind of institution, not very big. He had some freedom there. It was better than Pastra. We traveled a lot abroad because there was hearing, for example, for the general measurement on the decision, and he was present his case in Strasbourg once. Then we were invited in Dublin. He started to speak and develop his advocacy capacity. And he worked with a Canadian lawyer. He realized it's not my case, it's his case. And he's the person who can tell people about what happened in the social care homes, how it's terrible, and he has this power. I was witness of this transformation, just a victim of the system to somebody who can be an advocate for freedom.
The judgment had less of an impact in terms of his legal position, but it was very important for empowering him, for building him as a person.
Actually, asking me this, I remember in the plane for Strasbourg, we had a long discussion about the case, and he wanted to speak in the front of the court, and he wanted to tell them, I'm a person, I'm not an object. They haven't a right just to move me here and here. He wanted to speak, the court didn't allow him, so I spoke instead him. And I took specific time in the end to say exactly his words to the court. From this point of view, he was sure about his message, but the development as advocate, it was some kind of personal growth for him. The contact with people, with all this international community, this changed him. The work with this Canadian lawyer, it was very important for him. And we allow him to start building his own speech, not to intervene him, not to tell what to say, how to say, helping him to find his own words, how to express his feelings and experience. The fact that people came to see him, not me. I couldn't forget the moment when he realized this and told me, you are in the public. I am the important person here. Then I went in the public and he told me, oh no, not so far. So it's not the case itself. It's the whole part after that. And actually, I want to stress here that, yes, the case is very important, but I'm super proud from everything happened after that. It's not easy life for Rusi. The case didn't change his human life, but all these paths through the international society, recognition of his experience, this was the most important thing for me, and I'm really proud of it.
I see. Thank you, Aneta. Could you tell us a little bit about the impact that this judgment had on the legal system in Bulgaria?
Speaking for changes in the legal system, I have to notice here that the decision came not alone. In the same time, Bulgaria ratified a Convention for Rights of Persons with Disability, or CRPD. So the combination between the decision and the convention started to making change in the legal system. Not immediately. The first thing happened was the change in Civil Procedure Code, which allow now people to start case for removal of the guardianship directly. So they have access to justice now, especially for this topic, removal of guardianship. Later, there was change in the legislation related to social care. Now we have Social Assistant Act, according which the placement in social care home is possible only with a court decision if the person is placed under full guardianship. Also, the law requires that wishes of person with disability have priority before the opinion of their guardian or a social worker. It's on theory, it's in the law. It's not very well exercised, but it is in the law now. Also, there was a lot of work done in Bulgaria for creating new law for replacing guardianship and to be replaced with system of supported decision making, which never happened. But anyway, there is several rules in the law which introduce the supported decision making as a concept. They are not practical, and taking into account the court decision in Stanev case and the fact that Bulgaria is a side to CRPD already, we have to acknowledge the change in the case law, because the courts start to recognize CRPD rules and start to apply Article 12 directly, which means that many people with disabilities start to have chance to start cases directly only on the ground of Article 12. Even the national law doesn't allow this.
In Bulgaria, a person who is under guardianship still cannot file a case in court.
Yes.
Except if it's a case about the guardianship.
Yes, but if they are under partial guardianship.
And only if they are under partial guardianship. And you've mentioned that the courts now should listen to the wishes of persons with disabilities in cases. And what is your experience?
Actually, there is a procedure for hearing of persons with disabilities placed under full guardianship when they should be placed in the social care. Not only big institutions, but also group homes. But actually, even the court put the maximum efforts to understand the wishes and preferences of persons with disabilities. There is very well-informed judges, very progressive, who put maximum efforts to understand the wishes of persons with disabilities. But in some cases, judges don't take this serious, and labeling people with disabilities as not capable to care for their own affairs makes judges to think that they couldn't have a proper opinion.
So if I understand correctly, the practice is patchy, with some judges listening to persons with disabilities, with some judges not really listening to persons with disabilities. I'm wondering, Vladimir, if you recognize some of these challenges that Aneta has mentioned.
Yes, Aneta said a lot of things change after this case. For example, from my practice, I cannot imagine that a person with disability is not heard at the court. It's a rule. It's even in the law when it concerns a case for lifting the guardianship, for example, or for putting guardianship. But not only this. For example, recently we had a client who had a case for allowing him to vote for the EU Parliament. I have to mention that the client is put under full guardianship, but he considers that the Bulgarian law violates his rights, which are guaranteed by the EU law. And that's why he initiated the procedure for allowing him to vote, which ended up in the court. But which was a good practice here is that the court decided to base its decision on assessing the capability of the person to assess the needs for voting, the result of voting, and what is he voting for. So the court declared that would base their decision on this. But the good practice ended up here because the court decided not only to hear the client in the court hearing, but also to appoint a forensic psychiatric opinion, which was very biased and actually based mainly on his previous file from hospitals. And eventually the court rejected this.
So this client wanted to vote, right?
Yes.
And then the court, what were the questions that he had to answer in court so that he could vote in theory?
Well, some of the questions were connected to the voting itself. Does he know what will be voting for? Does he know some of the persons who he would like to vote for? But some questions were general. For example, does he know what year is now? What is the Europe Parliament also? And I think he managed to answer most of the questions, but for those that he couldn't, his answer was, look, I'm put in an institution. I cannot even watch TV, so that to inform myself. And this was very reasonable. I should mention, connecting to the institution part, that the court obliged those who are in charge in this institution to bring the clients to the court hearing.
And the judgment, so this client was asked several questions about his voting, some of which I think many of us wouldn't know perhaps ourselves, like what is the European Parliament and what does the European Parliament do, I think. But I'm curious about the forensic opinion. So if I understand correctly from what you're saying, the judgment was ultimately based on the forensic opinion.
Yeah, because the questions to the expertise was whether he understands the process of voting and what he will be voting for. It's kind of the same questions to the client, and the expertise itself, which was very, very, very long and based on his file from visits of hospitals, psychiatric hospitals, had very short conclusion that he is unable to form a political vote.
Did the expert meet with the client?
Yeah, the expert had to meet with the client. Nevertheless, his opinion was based most of the history of his...
on his medical record.
Yeah, medical record.
So it feels on the one hand that what is being given with one hand is taken with the other hand sometimes.
Of course, yes.
I wonder, because your clients, these cases take years before a judgment. What is your opinion about the clients and what keeps them in persevering despite the time that it takes?
Well, most of the clients believe that the domestic court and the European Court of Human Rights are last resort, but also most of them consider that this is not only their private case. They believe that they are part of some bigger cause, which litigation can change the situation not only for them, but for persons like them, to change the system through positive litigation. And this is the way they see themselves like figures in this litigation, because they want to help people like them.
What about you, Aneta? What do you think drives the client's motivation to keep litigating?
I completely agree with Vali. This understanding of the bigger cause, the potential to change many others' lives.
And what do you think litigation can bring to the clients?
Maybe the first thing that litigation brings to the clients is the positive feeling that something is happening, that someone is working for their problems and trying to help, because they're not forgotten this way. The more people are enlightened for their rights, the more litigation could evolve, which could lead to positive decisions. Or the opposite, if negative domestic decisions may result in good decisions of the European Court of Human Rights, this could change policies. Persons with disabilities who have positive experience through litigation naturally become advocates for disability rights. And Rusi Stanev is such example, but there are many more.
How about you, Aneta? What do you think? What can litigation bring to advocating for disability rights?
The litigation needs some preparation, some thinking about the structural problems and naming with legal term, where is the problem, what is the problem, can change the political efforts, even the advocacy efforts, even before the decision, because naming with the terms of law the problem change the game somehow. It's super important. It's a kind of using the language of law. For example, we can name the social care in the institutions social care. We can name torture, and all help us to make this distinction.
That is very interesting, and I think it's a good bridge to my next question, which is what happened to social care homes in Bulgaria?
Some of them still exist. Some of them are still object of interest of international bodies like Committee for Prevention of Torture. And the reports are very worrying because severe violation of human rights are still there. Some of them are closed, like the social care home in Pastra, where Rusi used to live. It's closed. People are moved in group homes. And in many group homes, the situation is not better, in my opinion, than in the bigger institutions. The small group homes are still institutions. Even they are smaller, new built. In some cases, the new group homes are created in the former institutions, in the yard or in the same building. Even it is prohibited. So, question was, what happened in the social care institutions? They're still there, unfortunately.
Just in a different form?
Some of them still exist in the same form.
Can I ask you, Vladimir, why is it in your opinion that the small group homes, the ones where 8 persons with disabilities are living at a time, are still institutions?
Because actually nothing changed in the treatment of these people. Yeah, the group homes are smaller. Yeah, they're in better condition than the former ones. But this is institution after all. It continues some rules that people live like they're in prison, like they have to do particular things every day, to wake up at the same time, to have breakfast at the same time, have lunch at the same time, to go to bed at the same time. They don't have the choice with whom to live. That's why it's an institution. Nevertheless, it's a smaller one, and practically nothing changed.
From the legal perspective, I am wondering, what do you think would be an immediate change that should happen?
Actually, possible, even it took so long time. The replacement of guardianship system with supported decision making system is crucial because it will open the door for many other changes.
And could you tell us a little bit about the supported decision making system? What does it mean in your view, supported decision making?
In previous years, there was process for drafting new law about the supported decision making. And during this process, which took several years, many lawyers and experts from social fields and professors in law came together and created this draft law, which introduced the system of measures, including support in decision making in the area the person needs this support. Also, preliminary declaration, which can be created by a person with psychosocial disability in time of remission, how he or she wants to be treated in time of crisis and so on. And the good thing for this work and this draft law was that everything is based on experience. Several organizations applied the proposed rules in real cases. They work directly with clients, applying these ideas, and it became clear that supported decision making as a process led by experts who are well educated for human rights and disability rights can change dramatically the life of these people. Also, people with disabilities were involved in creating some ideas like a preliminary declaration. And I have to say it's really working very well because I took this idea in my practice and supporting our clients. Sometimes we are able to apply this and it's working really very well.
And what do you mean? Can you give us an example of a preliminary declaration and how it worked in your practice?
Yes, of course. For example, we have a client who has a crisis time to time. So we sit together with her and created a plan what we have to do in case of a crisis. So she appointed 3 people of trust. And if all 3 people decide that she has to go in the hospital, one of them has to put her in the hospital. And she put us in connection. And we were in touch when this happened in the reality. Also, he gave us symptoms. For example, he told me, when you notice that I'm doing this and this and this, you have to ask me to go in the hospital. It was surprising for me when this happened, but I knew because I had her instructions what to do. So I contacted other 2 people and we placed her in the hospital, and she agreed because it was not involuntary. She agreed because she knew this is the rule, and she created the rule, not somebody else. I have to say, it was several years ago. After that, she hadn't hospitalizations anymore because it's work. It's make her life better. Of course, years after that, we noticed that we need change because the situation changed. We need new rules, and we have to start working on these new rules now, I hope. But yes, her life changed dramatically. And also introducing the system of support people to communicate better their problems, like an independent expert who help the people with disabilities to communicate with court, because without this, it's very difficult to follow this complicated legal procedure. It's difficult for people without disabilities. What about people who spend life in the institutions or who have, let's say, intellectual disabilities? So it's a very important tool for people with disabilities to have access to justice, but unfortunately it's not recognized in Bulgaria yet. There is a small program. People who are in this program are speech therapists who have knowledge how to help people with disabilities to express themselves and how to make the complicated legal language easy to understand for people with disabilities. So that is super important. I want to see such an expert in each level. It's if a person with disability can reach intermediary in the beginning of the procedure, the chance to win the case is much bigger than if there is nobody to support.
Do you have such examples of positive examples of intermediaries in your practice?
No, in my practice I still haven't, because we hadn't a chance to use this. But I know a criminal case when a person with disability was only the witness of the crime. So the judge invited intermediary to help person to describe what happened. And without this expert, the judge never will understand what exactly happened during the crime. because it's just a small problem in Bulgaria. It just started. It's not regulated by law. These two things, if they happen, they will affect many other. And I think it's just political will is missing.
Thank you. I would be very curious from you, Vladimir, if you could give us some examples of what you think should change in Bulgaria for the benefit of persons with disabilities.
Well, one of the main changes I'd like to see is more colleagues who are to be involved in litigation for persons with disabilities, because this would lead to not only quality but then quantity change in practicing such litigation.
Why is it, in your opinion, that there are such few lawyers working on this type of cases?
When we search for some practice, for some cases, we cannot really find any in Bulgaria. For example, about the mentioned voting rights case, there was nothing before us. I'd like to enrich the court practice.
I want to add something. Listening, Vladi, I start to think that we need not only quantity of new lawyers, but also quality. Because being lawyer means to follow the case law, to do what is usual. But doing strategic litigation means to have a bit creative, to use law, legal norms in quite different way, to combine national law with international law, to collect case law not from our country, but also from European Court of Human Rights and even other countries. It's a very difficult work, actually. And lawyers who are doing this work should be a little bit more brave than usual lawyers, because doing strategic litigation means sometimes to face rejections, to have an upset judge in front of you, to have blaming even that you are not working in the best interest of the client. We need brave and more creative lawyers.
So if I understand correctly, we need not only more lawyers, but better lawyers and lawyers who dare to challenge the system.
Yes, and better educated in human rights, disability rights, international case law.
Thank you, Aneta. Thank you, Vladi, for your very interesting insights. We have discussed about the case of Rusi Stanev versus Bulgaria. And as we have said, this case is one of the very important cases, not only for Bulgaria, but for Europe and worldwide in the field of disability law. It is a case that tackles institutionalization of persons with disabilities. It also tackles the topic of guardianship. To close our conversation, I would perhaps like to ask you to make one final remark on the challenges that you see in your current practice, which you would perhaps try to undertake through litigation in the near future.
We've noticed that the European Union is financing the creation of infrastructure of group homes, which, if such financing didn't happen, maybe most of the group homes wouldn't exist. So obviously the Union is nourishing the institutionalization, not supporting the institutionalization. So that inspired us to challenge in domestic level the creation of such group homes and especially the financing. Unfortunately, it didn't succeed because of the court didn't even recognize the legal interest of persons with disabilities who are the actual claimants. This case was a few days ago. It finished forever. But there is a special opinion of a judge of the Supreme Administrative Court who supported us in our arguments and accepted that persons with disabilities should be allowed to challenge this operational program before the court. We are considering to bring this case to the European Court of Human Rights, especially with the help of this special opinion of the judge.
I see. Thank you, Vladimir. I was wondering, Aneta, if you could tell us something about one challenge which you are planning to undertake through litigation in the near future.
It's difficult to say one challenge. I think it's more than one, but because it's the end of our conversation, maybe it's time to discuss a little bit from the broader perspective, because people with disabilities They're not out of the society. They're victims of gender-based violence. They're also victims of climate change. Some of them are refugees. Some of them are minorities. They have minority background. So we have to start thinking for these broader conceptions and to see people with disabilities in the context of the real life. Speaking for what we want to challenge, we want to challenge from this broader perspective, the discrimination against people with disabilities.
Thank you, Aneta. Thank you, Vladimir, for this very inspiring discussion. Thank you for listening to us. For those of you who are interested in following the network of independent experts further, please access their website at www.nie.expert. Their website for now is only available in Bulgarian, but please feel free to access their Facebook page, Network of Independent Experts /NIE. Thank you very much for listening and have a good day, everybody.
Thank you for tuning in. We hope you'll join us again next time as we continue to advocate, collaborate, and innovate for disability rights. We also would like to thank all our speakers for sharing their experiences with us and for allowing us to learn from and build on them. This podcast was brought to you by the Litigate project.